5 years?
Yes, Chief Justice.
And for how many years have you been a magistrate? If you combine district court magistracy and regional court magistracy?
I think this is my 21st year.
21st year.
Yes, Chief Justice.
And for how long did you act as a judge?
I have been acting as a judge intermittently from 2011. I think I had a stint in 2011 and in 2012. Thereafter, there was a break, and I think I started again around 2019. And I had another.
If you bring it down to weeks or months, how long would you say you have acted for?
Approximately 30 weeks, Chief Justice.
And I take it that you consider yourself to be ready, otherwise you wouldn't be here.
Yes, I think so, Chief Justice.
Thank you very much. Colleagues, let me have the names of those who have questions for Ms. Mokwera.
Makwanisha. Nyambi.
Singh.
Onod.
Schlemmer.
There's a colleague almost at the same time with Advocate Kane.
It was Tepeche.
Okay, all right. So it's Prof. Advocate Kane and then Commissioner Tsepe in that order.
Thank you, CJ.
I didn't leave out anybody there.
Baba.
Okay.
You got my name, CJ?
I do, Honorable Baba.
Thank you so much.
And Maya, CJ?
Okay, President. Judge President, over to you.
Thank you, Chief Justice. Ms. Mokwera, can I just get clarity? For how many weeks have you acted?
If my calculations are right, around 30 weeks.
Yes. And in KwaZulu-Natal, this was mostly in Pietermaritzburg, if I'm...
Mainly, I have never acted in Durban,
Yes.
JP.
And in Maritzburg, your duties was by and large again in the criminal courts, if I understand.
It was crammed,
Yes.
JP, say for the two stints, 2020 and 2021.
You did civil.
I did civil motion court mostly.
Did you ever complete a civil trial? I know you did many criminal trials.
The only trial that I'm busy with now is a divorce trial.
No, because I had gone through your papers you submitted, and I don't see a civil judgment. Did you submit a judgment for any?
I think I submitted a civil appeal.
Yes,
I
but
did not submit a civil judgment,
so did you ever complete a civil trial?
not in the High Court, JP,
So most of your trial work was confined to criminal work
to crime, but I've been doing civil work since 2010 in the regional court.
in the regional court. And do you find it any different, regional court civil work? And, well, I know that you have been allocated some civil duties in Maritzburg because I told him to give it to you. Do you find any difference?
Speaking from the view of motion court,
Yes.
I realized that the files are many and they are voluminous. They require a lot of reading. And the cases are a bit complex. There were some matters that I met for the first time in the High Court that we do not deal with in the regional court. In the unopposed motion, like I did provisional liquidations, insolvencies,
Yes. Just-
and but I think the complexity and the volume of the work, that's where the difference is. Otherwise, I realized that the rules are almost very similar to the rules that we apply in the regional courts.
Well, what I want to know is the volume of work. It's true, in Maritzburg, they'll tell you it's not as voluminous as Durban, but there is quite a bit of work in Maritzburg. Did you cope quite well with what was assigned to you in the civil courts?
I'd like to believe so, Chief JP, because I would. I heard that some acting judges would take forever in the motion court.
Yes.
I could deal with the role within unopposed motion within around 2 hours. I would be done.
Yes.
I think it all depends on preparation, reading and understanding what is in the file, what the issues are, and preparing adequately.
Yes.
I think in 2019, in both stints, I could even give extempore judgments in opposed motion.
Oh, did you give any extempore judgments in opposed motions?
I did I did, JP.
What were your main challenges with the work that you were given in the High Court?
Like I've indicated, mainly, I noticed that being in the High Court would require one to live a life of a recluse because you are confined to your chambers. You do a lot of reading, especially when you are doing civil work, and you're expected to do a lot of preparations. Even on weekends, you take a lot of work home to read, go through the files, and adequately prepare for court. So the challenge is that I would say it's just the amount of work that is there.
Yes. And you
But I'm very grateful because I'm one person who's got this personality of approaching people and asking for help. And I'm grateful to the judges who are always very willing to help. And I have benefited a lot from just the two stints that I had to do motion court.
You think you can adequately cope with the workload?
I believe so, JP.
And you don't think you might have a slight disadvantage with not having actually experienced the Durban High Court as such?
No, I don't think so. The thing with me, I am a fast learner, and I do not struggle to adapt. In fact, I enjoy challenges. I love things that challenge me to push myself more.
Yes. Thank you, Chief Justice.
Thank you, Judge President. MEC?
Thanks, CJ, and good afternoon, Ms. Mokhwara.
Good afternoon, sir.
Well, one of the problems that we face as society is the issue of gender-based violence and femicide. And in the course of the public debate, courts also get to be blamed for being too lenient on the perpetrators. And therefore victims finding it difficult to feel justice being served. So you'll find the perpetrator, some of them caught red-handed, out on bail immediately, and then the case doesn't move. Other cases don't move at all. You have the police blaming the NPA and the courts and the other way around. So do you think that criticism is justified? If so, what is it that can be done to ensure that courts also assist in dealing with this scourge that is inflicting our society?
Gender-based violence is indeed a matter of grave concern in our society, and especially here in South Africa. And the perception that courts are not doing enough, I do not believe that it is absolutely or 100% correct. One should be mindful of the fact that all the courts can do is to adjudicate cases based on the evidence that is presented. What is crucial is that the gathering of evidence, the investigation of cases, and the presentation of evidence before court by prosecutors should be of such a standard that the court at the end of the day would be able to make a finding that the guilt of the accused person has been proved beyond a reasonable doubt. And that is a very high standard of proof. So there is a requirement. Perhaps what needs to be strengthened is the investigation of such cases and the training of people who gather evidence, being the police, the training of prosecutors who have to present the evidence before court, so that at the end of the day, the court is able to make a finding of guilt. As far as sentencing is concerned, we are obligated, we have to rape and murder, because we deal mostly with, in gender-based violence, we deal mostly with rape and with femicide. Rape and murder are the offenses that have been singled out for harsh punishment by the legislature. And unless there are circumstances that warrant a deviation, we have to impose the sentences that have been prescribed by the legislature. So I do not understand the reluctance, because I, for one, I do not have that problem of sentencing. In fact, when life imprisonment was introduced, when we were given life imprisonment in the regional courts, I think in KZN I was the first magistrate to impose life imprisonment for a rape matter. So the best thing to maybe deal with a scourge that is plaguing the community, the communities, our society, is to impose sentences that will deter people from committing such types of offenses again. But it all starts with proper presentation of evidence. because once evidence has been presented properly before you and there's no other court that can differ with you, then your conviction and your sentence will stand and it will have the desired effect.
Okay, thanks so much, CJ.
Thank you, MEC. Honorable Mabanisha.
Thank you very much, CJ. Good afternoon, Ms. Mukhwara.
Good afternoon, Commissioner.
Yes, can you enlighten us why is the bar and advocates for transformation complaining that you do not start courts on time?
Thank you, Commissioner.
Even in the regional courts, there's the same complaint, and then you adjourn courts without any reasons, and that results in wasted time and delays.
Thank you, Commissioner. I was taken aback by that, by those comments. Let me just preface my response this way. In the regional courts, things do not always run as smoothly as they do in the higher courts. We have many challenges. The one problem that I can state without any fear of contradiction, even in our in the regional court, that I would like to highlight is among those problems, there's this one problem that is as perennial as anything of awaiting trial detainees being brought late. I don't know whether the minister is here. I'm glad if he's here because I know that he's also a minister of correctional services. Ever since I arrived in Pietermaritzburg in 2004, it has been a norm that we would, especially if you don't have a matter where you have people who are on bail or on warning, you would, as a matter of course, have to start court at about 9:30 or 9:45 because awaiting trial detainees are always brought late. This problem has been discussed in many case flow management meetings that I have attended. And I know that even regional court presidents from the the late Judge Nchangas, who was the regional court president at the time when I was appointed, he was aware of that. This is something that has always been brought up, even with Mr. Nzimande and Ms. Marx. It has been recorded in minutes. Add to that infrastructural problems that we have. Just the other day, about 2 weeks ago, I was in court when the recording machine exploded, just when we were about to start court. Sparks were flying all over. We were all terrified. We had to stop. The telephone lines have been down since last year. Last week, I had to give the prosecutor my cell phone to phone witnesses because there was a witness coming from Gauteng who had sent a message that he'll be arriving late to check how far the witness was. Add to that the issue of the prosecutors who only get to meet their clients, the witnesses, on the date of trial, on the morning of trial. And we are talking about people who are coming to testify about very serious issues, very serious matters of rape, of murder, of armed robberies. You have to at least give them some room, give them some time to consult, speak to these people. It would not be fair to just throw them in the witness box. And at most of the time, what they do, they just give the witnesses statements that what I've learned, because they don't get sufficient time to speak to their clients, unlike their opponents who get all the time to consult with the accused persons. So those are the realities that we live with every day. And I find this criticism to be so unfair because let me also state that advocates are occasional visitors to our courts, the lower courts. And I'm sure practitioners here will bear me out. Now, without specifics, because if I knew that on this particular day, advocate so-and-so came to my court and I couldn't start, I would be able to at least refer, because we are required to record reasons why we start late. So it's as far as I can explain it. I'm not saying that there
That's
has
fine.
been occasions.
Yes,
Is it okay?
Yes, that's okay.
Okay, thank you,
Uh,
Commissioner.
And then can you explain the judgment that has been reserved for 16 months? What were the reasons?
Okay, I'll need to refer to my notes. There were two judgments, but I'm sure you are referring to the one of Chamberlain versus Koning-Kremer. This judgment, I'm told, and I accept that it was argued. As my recollection of the matter is that it was a trial wherein the defendant raised 3 special pleas. So the special pleas were argued. And what used to happen was I would take the file with me when a matter is reserved, because I reserve judgment. I would take it with me and to my chambers and place it on the pigeonhole on my desk. It will be in that pigeonhole, so it would be a constant reminder for me to deal with the matter, to write the judgment. With this particular judgment, I am not really sure what happened. I suspect that I might have left the file in court when I adjourned court, and that it went back to the general office. Now, in that general office, we've been experiencing this problem of files being misplaced and files going missing. Because this file was not with me, and there were other things. It's not like when you are in the civil court, you only have to do civil work. There were other things, like I would be doing my partly head criminal trials. For some reason, because I didn't have that reminder, and it would appear I did not even record it in my diary, it just escaped my memory that I had this matter, until I was approached by an attorney about, I'm sure it would have been about the 11 or 12 months later, when an attorney approached me, not to inquire about this file, because I had written a judgment in another matter, which had been reserved for less than, I'm sure, for 2 months. This attorney, when she came to me, her name is Ms. Zama. Ms. Zama said, Ms. Mukwara, I'm coming to see you about the judgment of Mr. So-and-so, Mr. Maharaj, in my office. Mr. Maharaj was surprised that you have given judgment in my matter that you reserved 2 months ago. But there's this judgment that has been outstanding for almost a year now. I was taken aback. And I asked him, I even said to him, this is the place where I keep my reserve judgment. As you can see, the pigeonhole is empty. Because as far as I know, I've dealt with all my judgments. So we went with her after I had satisfied myself that that file was not in my office, to the general office, where I asked them to look for the file. Where the file was supposed to have been filed, it was not there, it was missing. And they told me that it could happen that the file has been, because it's already been caught, it has been put somewhere in the dungeon, where the files for matters that have been finalized are kept. So I insisted that they should go to the dungeon and look for the file. Needless to say, they did not find the file. When they didn't find it, after a week or so, I decided to contact the attorneys. I told them that I have encountered this problem. I was surprised that they did not even remind me throughout this period about this judgment that was outstanding. But I asked them to reconstruct the file for me, which they did. It was around, when Ms. Zama came to see me, it was around the end, towards the end of November. So in December, around when they were about to close, I inquired again. I had not yet received the reconstructed file. In January, that would be January of 2020. I was invited again by the JP to act, then I went to act. When I came back, it's only then, it was around March that I got the fine. Now, the challenge that I had in March was that there was COVID, and because of COVID, we could not work optimally in the office. From time to time, the office would be closed. I did not have a laptop until very recently. I only had the desktop, and all my research I could only do in the office. Be that as it may, in April, during the lockdown, I sat and I wrote that judgment and I delivered it electronically. This is something that I regret. I know that I ought to have been, to have exercised more care, but it's not the norm. Something was just unfortunate to have happened as it happened.
Thank you, Chief Justice. Thank you, Ms. Mohora.
Thank you, Honorable Mabanisha.
Chief Justice.
Honorable Nyambi,
Chief Justice.
is there a follow-up?
Yes.
Is that the follow-up? I think follow-up and then put whatever question you would otherwise have put to her so that I delete you.
Yes. Thank you, Chief Justice. Thank you, Chief Justice. Good afternoon, ma'am.
Good afternoon, Ms. Tsepe.
I just wanted to, one of the issues raised about the judgment, that the two judgments that have been outstanding, one for 16 months and the other for 5 months, they don't appear in your questionnaire.
Oh.
And I know that your questionnaire was completed a while ago.
Okay.
Why were they not included?
Okay, my understanding, let me indicate this. I got the nominations. You'll see that I got 3 nominations. They are all dated the 11th of December. In actual fact, the only nomination that I got on the 11th of December was that of Advocate Fleming. The other 2 I got on the 12th, the morning of the 12th, the one from Mr. Kunene and the other one is from BLA. That's when I decided that I'm going to avail myself and apply. So it was on the eve of the closing date. So I completed the forms in haste. Be that as it may, there is, if I refer you to the application itself, I think it is paragraph 9. It says, it speaks about experience when acting as judge. I misunderstood that. My understanding of it was, what was required for me was to indicate outstanding judgments, partly heads and others while acting as judge. So it did not occur to me that I should indicate regional court matters. That is why I did not. I'm sure if you can look at the questionnaire, you'll see that. It says while acting as judge. So I did not really think I should be indicating regional court matters. There is also, I did not even mention partly head matters. I had partly head matters in the regional court. There is also where it says cases that were overturned on appeal. It was also saying while acting as judge. So at that time, I was not aware of any matter of mine in the High Court that had been overturned on appeal. That is the only reason why I did not disclose them, not because I was trying to hide them or to be dishonest. In any event, it will be ludicrous to think that throughout the 20 years as a judicial officer, I would not have had any matter that was overturned on appeal.
Thank you. My second question related to the issue of your experience in civil matters. In your questionnaire, you do mention that most of your matters that you have dealt with are in the criminal court. Do you think that the amount of civil matters that you have done is enough to enable you to take on the function as a judge in the KZN High Court Division?
Commissioner, if I combine what I've done, the bit that I've done in the High Court with my experience in the regional civil court bench, I think I can be up to speed with the work in the High Court. As I indicated, I love to do research. I like to apply myself. I enjoy challenges. I believe I'm driven. I'm a hard worker. I think I'll be able to manage.
Thank you, Ms. Makwera. Thank you, CJ.
Thank you so much, Mr. Honorable Trevor.
CJ, I'm covered by both Makwanisha and Ms. Chape. Thank you so much.
Thank you, sir. The Honorable President. Well, it looks like the president is not there.
CJ, I thought you mentioned Nyambi earlier. I don't know if you skipped Nyambi and myself.
Can you imagine? Oh, that was because I went to Commissioner and searched there, and then I skipped you. Thank you so much. You are here. You are not scratched. Honorable Nyambi?
Thank you, CJ. Thank you, Commissioner Singh. It's in relation to the very same question of advocates for transformation. With the hindsight now sitting here, don't you think it was going to be in your favor before it's being raised here, because you are aware about the issues that they are raising and you've got a better understanding, to start by correcting what is wrong in your responses?
I don't quite follow, Mr. Nyambi.
The issue of reserve judgments, the issue of starting court late, adjourning early, and it's part of what AFT it's raising.
Oh.
So don't you think sitting here, because now we are aware what happened in relation to the judgments and the issue of the courts, before we can raise it? Because if it was not raised, it's something that was not going to be discussed. Do you agree?
Are you asking whether I should have responded to it before you asked me?
Yes, corrected it so
corrected
that
it by way of maybe a written response.
no, explaining it.
I didn't. I've been observing that with others. These things have to be elicited. I knew that you are going to ask me about it. I didn't expect that I have to come up with it, because nobody asked me whether any issue, even the CJ or the JP. If there's
But in simpler terms, do you agree what they've written that is correct? Your response is not correct about the paragraph they're mentioning.
Yes.
Okay.
Yes, I agree.
Thanks, Ms. Mokwera. Thank you, CJ.
Thank you, Honorable Nyambi. And Honorable Singh, it's your turn now.
Thank you very much, Chief Justice. Good afternoon, Ms. Makwera.
Good afternoon, Mr. Singh.
Thank you. I just want to follow up on these reserve judgments, and I see you've attempted to give us a reason for the 16-month delay on the one. Now, the other one was also delayed 5 months, and I don't know when it was delivered. That's the Saras Peramal versus Hemeline Chetty.
Okay.
How long did it take you to deliver that judgment? Because it was 5 months at the time when it still had not been delivered.
The judgment was delivered in April. Both judgments were delivered in April of 2020.
So how many months would that be after the matter was first heard?
The matter was heard, the quantum matter. It was, perhaps I should just give the whole background about this matter, Mr. Singh, if you allow me.
I think briefly, ma'am.
No, I'll try to summarize. This was a defamation trial. On the 11th of March, the issues were separated, issues of liability and quantum. On the 11th of March 2019, I gave judgment on liability for the plaintiff. Then the file had to be taken back to the general office because I was finished with the matter. On the 29th of April, that's when the parties came to set it down now for quantum hearing. At that time, when they set it down without me knowing that it was set down for quantum on the 29th of April, because the 29th of April that year I was acting in the High Court. That is the 29th of April when they came. And because I was not there, they adjourned it to June, the 14th of June. On the 14th of June, when they came, I was hospitalized. I had undergone surgery. And then they adjourned the matter to October. In October, when the matter came, the file was missing. That is when I asked that a duplicate file be prepared, because they had prepared heads of argument to be put in that file, and my judgment on liability. My intention was I would write the judgment because they had written quite substantial heads of argument. I said there's no need for them to argue the matter because they asked me, I had gone through the heads. I was satisfied that the heads were sufficient for me to decide the matter. And the duplicate file was opened. And then when I had to write judgment, it was in November. A need arose for me to refer back to the pleadings and to the notices, because especially when it comes to the issue of costs, I couldn't find the file. The file had to be reconstructed again. And I only got to get this again in March of the following year after I had acted in the High Court. And I also wrote the judgment in April. And the judgment was given in May.
No, thank you. Well, there seems to be quite a problem about missing files, but anyway, we'll deal with that later on.
Let me expand this further. It is a big problem, Mr. Singh. On Tuesday this week, I got an email from the High Court because there's a matter of the divorce matter that I'm doing in the High Court that was supposed to proceed in January. For some reason, because one of the counsels was not available in January, couldn't proceed. It was adjourned to April. The beginning of April, I went to the High Court to deal with the matter, only to be told that the file is not there. The file was missing. I was apprehensive because of this experience that I've had with missing files in the regional court. And I ordered that we proceed anyway because they were going to bring application for my recusal, and we dealt with the application and thereafter proceeded with the trial. After we had adjourned, after I'm trying to show this, to illustrate the point. After we had adjourned, I had very strong ways with this problem of missing file, that I can't have this in the regional court and in the High Court. And I directed my complaint to the registrar of the High Court. And I was told last week, the registrar sent an email informing me that the file was sent to you. I had never received the file because it was sent when I was on leave in January. And they sent me proof in the form of a copy of the register that the file was sent to me. And I saw that one of the assistant registrars in the regional court has signed for the file. The file was lying in the general office. It is only when I went upstairs to the general office to inquire about this file that it was given to me. It had been lying there since the 8th of January. So there is a problem.
Okay, ma'am, I'll accept what you said for now. The other thing is, I suppose, through you, Chief Justice, I suppose if I ask you why you did not indicate that you had matters taken on appeal in your questionnaire, item 9.4, you'll probably say, well, you thought it was when you were as an acting judge. Am I correct?
I had said that I thought that they were referring to when I was the acting judge, but I'm aware that there's a case which I only became aware of late, of State versus Kumalo, where my sentence was changed from life imprisonment to 20 years when I was acting. I was not aware of the matter at the time, Mr. Singh. I was not aware
Yes,
that my sentence had been reduced.
yes, thank you, because that's the matter that I wanted to refer to, State versus Kumalo. Because earlier on you said you are not afraid to give life imprisonment, but I see the full bench reverse that to 18 years imprisonment. I just
Yes.
wanted to say that and put that on record.
Yes, sentencing is it's a very difficult part of adjudication, Mr. Singh, and we differ. It can also be a very subjective exercise.
Thank you, Chief Justice. Thank you, Ms. Makwera.
Thank you very much, Honorable
Chief
Singh.
Justice, can I-
Commissioner Barnard,
Sorry, Chief Justice, can I have a follow-up?
I'm trying to make out the voice.
MEC Mshengu?
Yes, sir, MEC, please go ahead, sir.
Thanks, Chief Justice. Now, the issue of missing files is really troubling. Has there been consequences against those who, I would say, reckless?
You know, Commissioner or MEC, I initially I thought that perhaps it's because we are still, we didn't have civil jurisdiction for some time, and perhaps our registrars and assistant registrars needed training. As a result, from the onset, one was very patient, and you thought these are teething problems which would disappear with time. But unfortunately, I don't think the situation is improving. We have discussed this in the case flow meetings with the relevant stakeholders. I know that there's a Miss or Mrs. Khan who used to attend our meetings. I heard even from my colleague who is now sitting on sort of permanent basis in the regional court that the problem is still there. He even tried to introduce a system of a register to try and monitor the movements of files. But even somebody who is my brother and colleague, recently we were talking about this, and I was saying to him, I have to go to the JSC and answer about this issue of missing files. And he said, and unfortunately, the problem is still continuing. So perhaps it's something to be looked into to give necessary training. I know that even when I was doing civil work full time, there would be instances when attorneys would come to ask for certain orders during motion proceedings. And when you ask for proof of service to the other side, because you would not be having it in your file, you'd be told by the attorney that, but I did serve and I did file on a certain date. I have a copy. They would even give you a copy to see, to show you that indeed there was proper service, but it would not be in the file. So it's really something that needs attention.
Thanks, CJ.
Thank you, MEC. Commissioner Barnard.
Thank you, Chief Justice. Good afternoon, Ms. Makwera.
Good afternoon, Commissioner.
It just occurred to me the fact that these these cases in the other courts, other than the High Court, that were outstanding, was because you misunderstood the form. Are there any other, because these were raised by this organization, Advocates for Transformation, but are there any other ones that have not been raised that might still be outstanding or that were outstanding for very long periods that you can mention to the Commission?
No, not that I can think of, Commissioner.
Thank you. Thank you, Chief Justice.
Thank you, sir. Prof.
I'm covered, sir.
Thank you. KNSC.
Thank you, Chief Justice. I'm also covered.
Thank you. President.
Covered, CJ, but perhaps I could give my colleague, Ms. Mukwera, some advice that will help her never forget about a matter in which there's an outstanding judgment. Am I right, Ms. Oh, good afternoon, ma'am.
Good afternoon, President.
When you sit in court, you have your notebook in which you take notes, not so?
Yeah, the problem with the Magistrates Court, President, is that we use mostly, we don't get these books that we get in the High Court. We use what you call P21 sheets. And I would write my notes and put them in the file.
Well, word of advice, just get yourself a Q-Choir notebook from Pick and Pay, from Checkers, anywhere. Write your notes there and make it a practice that when you leave court, you don't leave it there for someone to take back to your office. You take it yourself back to your office. That's your diary. And that's what will remind you that on such and such a date, I had this matter and maybe there's something outstanding I still need to go back and do there. And you'll never forget a case again.
I greatly value the advice. Thank you, President.
Thank you, CJ.
Thank you, President. Ms. Mukwera, I take it you're aware that sometime in 2018, I visited the Magistrates Court in Pietermaritzburg.
Yes, CJ.
And I also assume that you are aware I didn't find any regional court magistrate there.
CJ, I need to correct you. I was there.
Were you there as a regional court magistrate?
I even went to greet you because Ms. Munyemore had told me that you were in the office. You would be coming to the office. You came with the JP. You were in Ms. Munyemore's office. And I
was in Ms. Munyemore's office.
Yes, and then I went and I greeted you. We even spoke. And in all fairness to my colleagues, I believe that they were there.
No, I asked.
No, you were misinformed, JP. My colleagues were there. I remember very well that after I had spoken to you, I even went to brag to them that I've been with the CJ. I've just spoken to the CJ now.
Yes.
And then they said, one of them asked, do you think he'll even come and see us here? And I said, I doubt he would rather visit the regional court president, not us.
I wonder what happened because I had specifically asked to see both district court magistrates and regional court magistrates.
No, you were missing.
I accept your word that you were there.
Yes, CJ.
I was told at the time that there was a tendency for regional court magistrates not to be there on Fridays from morning until knock-off time.
No, that's not true. That's not true. Even if some of them leave, I can vouch that there are those who would be there from 8 to 4 every day.
Okay, all right. Thank you very much, ma'am. You're excused.
Thank you, CJ.
Thank you. President. Good afternoon, Advocate Mossop SC.
Good afternoon, Chief Justice.
I noticed that you and I did our LLB at the same university.
I believe so.
But you qualified the year before I did.
Yes.
Well, on a lighter note, I draw consolation from the fact that I'm two days older than you are.
I see.
You've been an advocate for how many years now?
I joined the bar in 1996, so I'm in my 25th year.
And for how many years have you been silk?
I took silk on the 13th of December, 2015, so I'm into my 6th year.
And I take it that practice has been fairly healthy, you've been doing fairly well?
Chief Justice, touch wood, I've been blessed, I've been lucky. It has been good to me. Thank you.
Thank you. And you've acted as a judge of the High Court?
I have, Chief Justice, on a number of occasions.
How many weeks or how many months would you say it comes down to?
24 weeks, Chief Justice, and I acted the whole of the first term of this year in Pietermaritzburg.
Any serious challenge with delivering your judgment timeously?
Chief Justice, no. I have no reserve judgments. The longest time period that I've taken to deliver a judgment is 6.5 weeks. And that is out of character for me, and I need to explain why it took that long. It was an appeal judgment that was, we heard on the last day of my term. And as we walked out of court, my colleague said to me that I was to be the scribe. So I went back to my practice, tried to deal with what had happened in my absence, and wrote the judgment. And I sent it through to him on the 18th of December, which was during the recess period. And he only looked at it towards the end of January, and it was then handed down. So that's the longest judgment that I've ever taken to prepare. The next longest is exactly a month. That judgment is one of the documents that I submitted along with my application. And the next longest is 12 days. That was an opposed motion where a money judgment was sought on application for payment of the sum of 270 million rand. It took 12 days to deliver that judgment, and it's obliquely referred to in my application under the heading of have any appeals been taken against your judgments. That is the judgment that I referred to where I believed that the appeal had been abandoned. That's what I was told, that the application for leave to appeal to the SCA had been abandoned, but I subsequently discovered after submitting my application that it had not been abandoned, and it was considered by the Supreme Court of Appeal, and the application was refused.
Thank you, sir. Colleagues, may I have the names of those who have questions for the advocate, please? So there is nobody?
Dodovu.
Schlemmer.
JP?
Thank you, Chief Justice. Advocate Mossop, you've acted for 24 weeks. What did these acting stints consist of?
Judge President, the first 3 were civil appointments, and the last 2, the full term, the first term of this year, were in crime. But unfortunately, crime didn't run because of COVID, so I made myself available to do civil work.
Yes. So most of it was civil work for the period that you've acted?
That is correct, yes.
Yes. And crime didn't proceed because of the COVID situation? Yes. And how many weeks in Durban and how many in Pietermaritzburg?
So the first term of this year was in Pietermaritzburg, and all the other weeks were in Durban.
Do you find there's any difference between Durban and Maritzburg?
I think there is, Judge President. The workload, I think, is heavier in Durban.
Yes. And how did you manage to cope with that?
Judge President, I have a work ethic which is relatively well known. I'm a very early starter. So when I acted in Durban, I was in chambers at 6 o'clock each morning, and I would leave only when the work had been completed and I had completed my preparation for what was coming next. Unfortunately, I couldn't keep to that schedule when I was acting in Pietermaritzburg. I would get to court between 6:30 and 7 in the morning, that after having driven 90 kilometers to the court. But I'm an early person, I'm not a late night worker. And so I found it quite easy to handle the workload.
And your practice, what did that mostly consist of?
When I started originally, Judge President, I came from a criminal background and it was largely criminal, but that rather swiftly changed, and I would say for the last 20 odd years it's been primarily a civil commercial practice. I've involved myself in a wider range of matters, and I've sat in arbitrations both as an arbitrator and as a representative of parties. So it's largely now a civil matter. I haven't civil practice. I haven't been in a criminal court as a practitioner for a while.
And what is it that you think that you could bring to the KwaZulu-Natal bench?
Judge President, I think 34 years of experience over as wide a field as you could imagine. Crime, civil work. I've sat as a magistrate for 5 years in Durban. I regularly received commendations, and over 10, in fact, from judges of the High Court, or the Supreme Court as it then was, for my work, the clarity of my reasoning, and for the empathy that I showed when sentencing people, because I was in the criminal section. I think I have a broad range of experience that could be of some use to the community and to the bench.
Thank you, Chief Justice.
Thank you, Judge President. MEC?
Thanks, CJ. Just one question, Advocate. What do you think should be a cornerstone of a transformed judiciary system?
Well, I think the first thing that the Constitution mentions is that the profile of the bench should try and match the profile of society. I think they use the word should approximate towards what the racial profile of this country is. And I think that's important because everyone needs to have examples to look up to. So young black practitioners need to see black judges. So I think getting the racial transformation of the bench is very important. It should be given effect to, but not at the price of making the court less effective. The JSC needs to pick the right people.
Okay, thank you.
A follow-up, CJ.
Honorable Dodovu.
Thank you very much, Chief Justice. Good afternoon,
Good afternoon,
Advocate. I want to ask you questions around the presumption of innocence.
Yes.
A lot of people say one of the pillars of our constitutional democracy that is contained in the presumptions of statutes, it is that presumption that you are innocent until proven otherwise. If I'm facing serious charges and I decide not to step down from my position and that I'm fired or I'm suspended, what are my prospects of success if I go to court to challenge that matter?
It's very difficult to say. I first have to have a brief if I want to give you an opinion.
Yes, give me an opinion. And raise the appropriate fee.
I'm not sure that the presumption of innocence is something that extends outside the courtroom. I think that's where its true home is. I don't think that in your workplace or in such circumstances that the presumption of innocence is something that you can rely upon. I think in a court of law, it is essential, especially insofar as the criminal section is concerned.
Say in this case, I'm a church leader.
Yes.
Let me take that example, and I'm a president of a church, and that there are certain allegations about me. I'm charged in a court of law.
Yes.
And obviously, in relation to what you've just said, the presumption of innocence applies.
Yes.
But my church fires me for my position irrespective while the case is ensuing, and I'm not happy about that decision. Then I approach a court of law. What would be my prospects?
Well, you would have to take it on review, but it would also depend largely upon what your church constitution says, because the church is a voluntary association of people.
Yes.
And your constitution will tell you what your rights are if X or Y happens. So I would have to know what your constitution says in order to advise you on whether you have prospects of somehow setting aside the decision that you are subject to.
As my brothers here have taught me over the last, and sisters, of course,
Yes.
have taught me over the last 2 years, they say to me, no, it's okay, but remember, your constitution of the church is superseded by the constitution of the republic.
Yeah, 100%.
But you're saying it will depend on my constitution.
No. Yes, but so if your constitution has something in it that is contrary to the constitution of
Yes,
the country,
it's invalid.
you've got very slim chances of succeeding.
Yes, I'm asking you this question in the context of our constitution of the republic, thinking of the founding principles of our constitution. Hence, I want to test your knowledge in this particular instance.
Well, I'm not sure.
Because I want to decide whether to step aside or what.
That's a very topical question at the moment. I can't tell you what the answer is, because I don't know what your constitution says. I don't know if it conforms with what the constitution of this country says. Those are factors that need to be considered before a positive assertion is made by me. You may approach the court, and the court may or may not decide in your favor. But I don't think that anyone can be compelled to step aside if the constitution upon which that organization is based does not allow for that or does not require that to occur. So
I must say that this is a very contentious issue that I'm grappling with.
Yeah.
I guess other members here, colleagues, grapple with that, and we'll see how it goes. But thank you very much
Thank you, sir.
For your input. Thank you, CJ.
Thank you, Honorable Dodovu. Advocate Mosopa, I hope the colors of your tie did not drive the honorable member to put that question. Prof?
Yes.
Prof?
Good afternoon.
The microphone is on. Thank you, CJ.
Yes.
Can you tell us what your judicial philosophy is, please?
Prof, we live in a constitutional democracy, and I think that our philosophy should all be the same. We should be attempting to instill and carry forward the principles of constitutional democracy, and I think those are to be found in Section 1A, B, and C of the Constitution. Emphasis on human dignity, achievement of equality, and the advancement of human rights, the abolition of discrimination and gender discrimination, and an acknowledgement that the true law of the country, the principal law of the country is the Constitution, supported by the rule of law. That's what we should be striving towards.
Thank you. The work that you've done in the small claims court,
yes,
does that link up with your judicial philosophy and with your whole attitude towards the country?
Professor, I'm not entirely sure. It's done on an informal basis, and I think that if it did tie in with the Constitution, it may be in the sense of some form of Ubuntu being displayed, where you consider the position of the people, that they are neighbors, they might be friends. It's a more human approach, a more personalized approach than in the High Court, which can be rather informal. There we grapple with everyday real problems that people have. And it's an excellent place to reaffirm your values and it's a reality check, because, you know, in practice, when you're dealing with large commercial matters, it's very easy to lose sight of the value of a rand. But you'll see in the small claims court, people sue each other for 200 rand. And it's not being done just out of maliciousness or nastiness. It's because 200 rand is a lot to those people. So it helps keep you grounded. I hope that there is a constitutional imperative there, and we always try and make sure that justice is fairly administered. So yes, I think there is probably.
Thank you very much.
Thank
Thank you,
you, Prof.
CJ.
CJ.
Thank you, Prof. Yes, Commissioner Sigogo.
Thank you. Thank you very much, CJ. Good afternoon, sir.
Good afternoon, Mr. Sigogo.
Yes. I wanted to make a follow-up immediately after the MEC.
Yes.
The MEC asked you about what do you consider a transformed judiciary?
Yes.
And you indicated that it should be the one which reflects the demographics of the society. Then you continued to say, but.
Yes, I did say that.
The JAC must as well appoint the right people.
Yes.
Does it mean those who are appointed in order to reflect the demographics of the country, not the right people? Hence, we will need to appoint others who will then be the right people for the judiciary. I don't want to misunderstand you.
No.
I want to understand you.
No, I'm saying people of the right color. There are plenty of good people who should be appointed. That's what I'm saying. It doesn't mean that you have to appoint a white man because he's going to do the job properly. You need to appoint good black people to that position so that it broadly reflects the profile of this country.
So, and I think that is what we are doing, that when we appoint people, we're appointing people who meet the minimum threshold.
Yes.
Educationally, as well as in respect of their standing in as far as fit and proper is concerned.
Yes. But yes, no, if that is what the criteria is and that is what is applied, then you're doing a brilliant job.
So I'm worried about the but, because it gives an impression that it crushes all what you have said before you use the word but.
No, certainly it wasn't intended as that. There are many, many excellent black practitioners, white practitioners. You need to choose the right people for the job.
Thank you for that. Thank you, CJ.
Thank you, sir. Thank you, Advocate Mosop. See your excuse.
Thank you very much, Chief Justice. Thank you very much, Commissioners.
The candidate is ready.
Thank you, Judge President. Good afternoon, Mr. Ngosi.
Good afternoon, Chief Justice. Good afternoon, Commissioner.
How are you, sir?
I'm very well, thank you, Chief Justice, and trust you well too.
Yeah, I noticed that just like me, you started at Zululand and then went for LLB at the University of Natal.
Yes, that's where we originate from, and we're proud of it.
Yes. Tell me very briefly about the purpose of or the role of paralegals, very briefly.
Well, we provided them with basic training to assist their communities in rural areas of KZN in matters which, were prevalent at that time. They were administrative in nature, basically. So, I mean, issues that rated top of the list would be pensions. They would not be getting their pensions. And sometimes we find that they've just been stopped without a reason. Or in other instances, people have applied, nothing has come through, and they just sit there. So the role of paralegals was to come and close that gap and ensure that there is accountability from the administrative side as to what's happening. And actually, it instilled the interest in administrative law. Hence, when I served my articles, I ended up serving in a firm which had an administrative law department. And I've been doing that ever since.
Yes. Do you have some advice centers? Did they, not you necessarily, did the paralegals set up some advice centers in the townships, or are you not aware whether it went up to that level?
Well, at the time, they had offices in the rural areas because there were other centers in urban areas. So we concentrated exclusively in rural areas, which meant a lot of traveling for us. And we were youngsters from university, so traveling to rural areas, we had to acclimatize to that. So it was a very challenging time, but it was worth it because the money we recovered for those people, it was phenomenal.
Wow. And you've been an attorney for over 17 years, am I right?
I beg your pardon, Chief Justice?
You've been an attorney for more than 17 years, am I
27,
right?
actually.
27?
Yes,
Why do I always get calculations wrong?
I served articles in 2002.
Yes.
And yes, and then thereafter I went back because when I left the community law center where we were training paralegals, I said,
Yes.
I'm originally from here, from Gauteng. So I said, I want to go back to Gauteng to serve articles. They said, what if we find your articles here in KZN? I said,
when were you admitted?
In 1994.
Okay, all right. And you've acted as a judge as well?
Yes, I have. Since from
how many weeks, how many months? Or how many months?
Actually, I've done 9 stints now because I did my last stint recently. I was at the Durban High Court from the 18th of January and I finished on the 26th of March. So all in all, I did 9 stints, which is 4 months each. So it translates to about 36 weeks.
And for how long what is the longest you've kept the judgment reserved?
Well, I have very big practice. So once I go back to my practice, it's very difficult to write judgments. So what I've tried to do is that before I finish my stint, I've finished all my judgments. So I think, if I'm not wrong, I haven't kept a judgment for more than 6 weeks. Every time, by the time I finished my acting stint, all my judgments were done.
Thank you. Colleagues, let me have the names of those who have questions for Mr. Nkosi.
Mr. Gogo.
Singh.
Schlemmer.
JP.
Muhimang, Chief Justice.
Thank you, Chief Justice. When was your first stint acting as a judge?
It was in 2011.
And that was in Durban?
It was actually in Pietermaritzburg.
And who was the JP then?
It was Judge Patel, Chiman
Yes.
Patel.
Yes.
And I remember you were senior civil judge at the time, and the very first day I was given motion court.
Did I do that to you?
Yes, and in fact, I had a list of questions that I wanted to pose to the senior civil judge before I went into the motion court. And I got there at 7, hoping that I'll be getting the assistance, but I waited and judges started arriving at 8. And I thought by that time there were lawyers waiting outside to introduce themselves. But I did well and I finished the motion court within a reasonable time, which was not bad.
And my recollection of you as you did both crime and civil, and that has always been the case when you came and acted.
Yes, in each time when I did two stints, I will do the first one civil, do the next one crime.
Yes. Any challenges you found while acting?
Well, there were challenges in the sense that sometimes, there are instances where you don't get the administrative support that you expect. Court, the files will be brought to you late. The record is too thick. Then you have to try and go through it within the time, which is available to you. And other than that, there were things that I was acclimatized to, or I was used to, because I've always worked in a very busy practice. It's not unusual in my firm to find people working until 9 in the evening. So if it means working long hours, I could do that.
Yes. I see your practice largely involve local government and administrative law.
That's correct.
Yes. There's quite a bit of this sort of work coming up in KwaZulu-Natal.
Yes.
Have you done any of that work while on the bench?
While on the bench?
Yes.
I've had cases which relate to those fields while I was on the bench, and I must say it actually equipped me with the skills to deal with it because it's a specialized field. Even lawyers who show up in court sometimes are not very familiar with the legislation because there's a plethora of legislation that they have to go through. So what I would do is to guide them through it because of my experience. And it's come in very handy with me acting as a judge because it's a skill that's not usual. In the whole country, I think there are a handful of people who specialize in both administrative law and local government.
I also see from your practice that you didn't really litigate on your own.
I actually litigate because my clients are parastatals, corporate bodies, and other institutions which actually insist that they should be counsel. And I think there's good reason for that because as an attorney, I think I did explain this at my previous interview, that once you're seized with a matter as an attorney, you tend to actually focus on it subjectively through your client's point of view. You need somebody who is going to serve who's actually going to give you another perspective of things that you may be overlooking in the process. So having counsel helps in that because I know my cases very well. I'll sit down with counsel and say, this is what we need to do. This is the legislation. These are the facts. This is how I think we need to go about doing it. Counsel will give me feedback that, okay, I think you actually are overlooking this, this, and that. So that two-way process helps, as opposed to having me as an attorney going out to argue the case myself, only to find that there are issues that I've overlooked and they are brought to my attention in court, and I never thought about them. But if my clients say, we can afford it, get counsel, and I insist on doing it myself, it actually tends to be counterproductive.
Now, the fact that you haven't actually litigated on your own, so to speak, do you find that a disadvantage sitting on the bench as a judge?
JP, when saying litigating on my own, you mean like go and argue the case myself?
Yeah. Yes.
Actually, there are cases I don't think it actually affects me in any way because an attorney's practice is very busy and hectic. Advocates on the other, I'll have about in my diary every morning about 20 files that I have to go through before I go home. So if I have to sit down, draft particulars, prepare the pleadings and send them to court, go and argue the case, it tends to be counterproductive to my time as well. Yet if I actually formulate the issues the way I think they should, then thereafter I go to counsel, we sit down and say, this is what I've done. you run with it, and then we'll discuss it once you've actually got your teeth into it. It helps because the client gets the advantage of 4 sets of eyes looking at it as opposed to just 2.
Yes. Thank you, Chief Justice.
Thank you, Judge President. Honorable MEC.
Thanks, CJ, and good afternoon, Mr. Nkosi.
Good afternoon.
Do you think it's possible or even desirable that at some stage we can have paralegal work extended and tailor-made for judges as part of extending access to the judicial system?
Well, I don't see any reason why not, because as long as there are people who will be there to guide paralegals, because it's very important that you provide guidance to them so that whatever they do, they don't end up doing something wrong, which should then backfire, and then they find themselves being sued. So if you are going to put mechanisms in place which would serve as guidance for them, then by all means, I would say, let's incorporate them into the whole system so that it could just, as cascade upwards towards the courts. The mistake that we tend to do is that we tend to say, we want to extend justice. Well, let's bring more people in. And then we bring people in, but we don't equip them with skills to deal with issues that are going to arise. Then when things go wrong, litigation is very dicey because you can be sued for damages. Then they end up facing actions for damages, and there's nobody who's going to cover them because the chances are they won't be insured. So we need to be circumspect, but I think it's a good idea.
No, thanks, CJ.
Could I follow up on that, CJ? Very short one. JP
Yes, sir.
Thank you.
Yes, sir.
Good afternoon, Mr. Nkosi.
Good afternoon, Mr. Matonsa.
I know I don't look like him, but anyway.
Oh, I beg
No, that's Judge President.
my apologies, Commissioner. I thought it's coming from Mr. Matonsa.
The JP is taking compliments. But they do look alike.
My apologies, JP. I was looking the wrong direction.
Thank you. Mr. Nkosi, your work with paralegals is impressive because it's one of the bases that buttress access to justice. You know that. I suppose that's why you do it.
Yes.
Now, my question is, your expertise in doing that, if we recommend you for appointment, would you be in a position to assist the JP, and I'm saying this because I didn't hear you mention it, in establishing pro bono help desks that are manned by paralegals in the high courts, because it's a model that works elsewhere. Because the problem is high courts daily have unrepresented people who come, and when you want to respect the equality of arms principle, you've got to assist them one way or the other, and that model has proved to work.
I'll be more than happy to assist in that regard if I am asked to, and in the event of me being appointed, JP. Thanks.
Thank you, Mr. Nkosi. Thank you, CJ.
Make a quick follow-up, CJ. Sir Taba.
Yes, Honorable Taba.
Thank you very much, CJ, and good afternoon, Mr. Nkosi. I need to call you by your first name.
Yes,
just as a follow-up to the questions that have been raised on paralegal training. Back then, I'm not too sure if it is still happening now. Universities used to conduct community law clinics. And you have been involved in paralegal activities. If you are successful, would you support government, or rather, let me say, traditional authorities who are now, in terms of the law that will soon be passed and signed into law by the president, the traditional courts bill, would you assist the province with the capacitation of those who would be designated to dispense justice in inverted commas, as it is envisaged by this bill that will soon be passed and signed into law by government, is an area that many people, especially in rural areas, saying has not received sufficient attention, and that needs to be, attended to. Would you be of assistance if you are successful in this position in that respect? Thank you so much.
Yes, I will be. And the advantage is that I've done it before, and we did it very successfully. We covered the lengths and breadths of KZN in areas where I never thought I would be. And we would get there first, get to know the culture of the people and get to know the people well, get introduced to the Inkosi. Once you've actually done that, it helps because then the people buy into it. Then you build structures which are going to be of assistance to everyone. So I think it's a very good idea if it can be taken forward.
Thank you so much, CJ.
Thank you, sir. Commissioner Sigogo.
Thank you. Thank you, CJ. How are you, Mr. Nkos?
I'm very well, thanks. And how are you, Mrs.
I'm good. And how is Mr. Amson?
He's very well too, and I'm sure he sends his regards.
Okay, thank you. My question is on Paralegal today. The follow-ups nearly touched what I wanted to ask you on. You for sure value the work of paralegals. The Legal Practice Council, in terms of the Legal Practice Act, is required to advise the Minister of Justice, who is fortunately with us here today, on the regulation of paralegals, whether they should be regulated with other legal practitioners or separately. What do you think? And let me leave it there. What do you think?
Yeah, I think regulating them without putting the framework first may be a bit problematic. So what I think we need to do is first let's put them in a position where they can deal with the matters which are presented to them. And then once we have done that, then we can start regulating because they will know what their responsibilities are and how far they can go so that they don't end up trampling on the toes of attorneys who would say you're taking our work, or advocates saying you are now impinging on what you shouldn't be doing. So we need to actually try and balance the scales in such a way that they are going to know this is how far their lane extends. And from there, if issues are beyond their comprehension, they need to be dealt with by attorneys. But I think it's doable. It's a process that is actually capable of being done.
Thank you very much. Thank you, CJ.
CJ, a follow-up for me.
Thank you, sir. Please go ahead, Commissioner Matolo Tlepo.
Thank you, CJ. Thank you, Mr. Nkosi. You know, the paralegals, for me, it's one of those, that community that we need in South Africa. And we need to do it in such a way that they feel respected. And as Mr. Gogo said, we as the Legal Practice Council, we had to advise the ministers, but when we engaged with them, some of them felt that their only issue is funding. And funding, the government is not doing anything about their funding. And so I'm just trying to tap on your knowledge that what do you think is the best way for us to go? So that the organized profession doesn't feel they're competing with them. They are necessary, we need to do something. I mean, they are providing access to justice, but what do you think can be done?
Yeah, I think we actually need, the starting point is first to ensure that we get them to understand their terrain, that this is what you are expected to do, because the importance of them is that they are like the rubber on the road. They are the ones who are in direct touch with communities. But if they can do that without support, then it's not going to be of help to anyone. So if the government can set aside a portion, it can make an allocation that let's try it out on a pilot project basis. I think it's something that can, once it's off the ground and we can see that it works, then we can even get the private sector chipping in to actually add to the cost that is required to make it a success. But the starting point is first, let's sit down, put the framework on the table, get the organized legal profession to buy into it so that we're not going to get people saying you're taking away our work. We now, because people are coming to you for free, because paralegals will be charging close to nothing, if anything at all. So we need to make the organized profession, legal profession, that these are people who are actually going to complement the system that is available, not take away anything from you.
Just for further follow-up, the organized profession has come to terms that we are understanding that we need paralegals. They have to be there. They are not taking their work, and they are very. They're actually. We know our roles both, but the only issue that I had, because I thought maybe if we say the legal profession can actually assist the paralegals, like community-based organizations, as a pro bono service to them. Maybe a firm of attorneys goes there once a week to facilitate whatever matters. I had that in mind, but I just wanted to know what you think about that.
Yeah, in fact, sorry to cut you short, Commissioner. When I was at the Community Law Center, what we will do is that they will take cases as and when people were coming in. And then because they are far from us, we would have weekly or bi-weekly visits. So they would have cases that they are going to deal with. They'll tell us, we've dealt with these. They are straightforward. We tried dealing with these, they are too complex. And then we will sit down with them and say, let's see where you fell short or where you went wrong. They'll say, well, I couldn't understand this, or I went wrong here, or people came back with me. So we gave them the guidance on an ongoing basis so that they didn't feel like we just dropped them in the lurch for them to try and swim on their own without assistance. So if the legal profession buys into it, I think it's a very good idea that you're suggesting that attorneys commit that we will be there on an ongoing basis to help. If you need a problem, pick up the phone, or let's arrange a day when I'll come to you, list all the problems, and we go through it. And in the process, I educate you how to deal with the same problems if they do arise in the future.
Thank you, CJ, and thank you, Mr. Nkosi.
Thank you very much, Commissioner. And just by the way, Mr. Nkosi, what I've picked up is that those that have been properly trained help to ease up the role of both the magistrates' courts and the high courts, because they solve most of the problems before they get to court, and they direct people correctly to where to go when their cases have got prospect of success. Indeed. And those that have partnered with the magistrates, like the magistrates' courts in Harankua, for instance, have helped the justice system enormously in reducing the caseload and ensuring that people get proper guidance before they waste their money in litigation.
Indeed, CJ. In fact, it's streamlining the process, making sure that it cascades to the correct level, because it's pointless someone going to an attorney with a claim that's, with something that the paralegal will resolve in a few hours. Yeah. Then the attorney is going to charge fees and stuff like that. So we need to avoid that if we can, as much as possible.
Yeah. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Mr. Nkosi.
Good afternoon, Commissioner Singh.
Yeah, I'm very pleased that you are offering yourself to the bench with all this wonderful experience that you've got. But what I'm trying to understand is that you are not only a partner, but a director of one of the larger firms in Durban, very, very successful firms. And you said it's a very, very busy practice. You've offered yourself intermittently from 2011 to now in acting positions. I just want to know what motivates you to now join the bench? What is that motivating factor that want you to join the bench and leave a thriving practice?
I've done what I'm doing for 27 years, as I said. It ends up breeding complacency, that it comes too easy. And I think it gets to a point where you think your mind is not stimulated enough to expand. So as I get called to act, and I'm very grateful to my partners because they've never raised an issue, although I have a budget to write like everyone. So for that, a credit goes to them. But the thing is, they've allowed me to do that as part of first making sure that our practice also contributes to the legal profession in our province. And at the same time, for me as an individual, it makes me grow because every time I've acted, I've acquired experience which is invaluable. And when I go back to my firm, I go back as a better lawyer than I was when I came in. So if I end up joining the bench, I know it will be the blessing of my partners, and I will make a difference. And they would also say, that's one of our own and is making a contribution to the legal profession in our province.
Yes, one of your partners was a commissioner as well on the JSC of your company.
Incidentally, I was his tutor at varsity. So he and I have gone the same paths because he was a very diligent student. The others, I would have to chase them to tutor them. In his case, he'll be working outside my dorm room every evening, and to the extent that I was the one who had to run away for him at times.
Yes, that's Commissioner Msomi.
Yes, that's him.
Yes, CJ. My second question relates to an answer you provided under legal background, where you appeared for Abahlali Basenjondolo. And you say you criticized the majority judgment of the Constitutional Court in that matter. Yes. I'm just trying to understand, I couldn't grasp from what you wrote there, what was the nature of the challenge and why you criticized that.
Okay, let me try and explain the issue quickly. What the province came to me, to us at the firm, and said, we need to eliminate slums in the province. We need to come up with legislation which will enable us to do that. But we don't want to render people homeless in doing that. So how do we go about it? So we sat down in the province and said, okay, let's work through what the provisions of the legislation are going to be. First, you can't render people homeless because the Constitution says you must move them from a place and put them in another place. So the province said it's fine, we'll have transit camps where if people are moved and housing is not ready, we'll put them there. So we said that's fine. And if you move them, it has to be in terms of pie. There's a legislation that actually regulates how you go about doing it. That's fine, so we did that. And then we had road shows where we explained that to all the people who are going to be affected, including people who live in these areas. Once we did that, and then we drafted the legislation, went out and said and explained it to the people what the provisions are. Then Abahlali took the legislation they wanted to challenge the constitutionality of the legislation on the basis that it's going to render them homeless. And we explained to them, a countless number of occasions that no, what the province wants to do is to actually either upgrade the slums or the informal settlements in situ, which means where they are. If they are not capable of being upgraded, move people to places which are actually habitable, fit for human habitation. And nobody's going to be rendered homeless in the process. They were not satisfied with that, so they took the case to the KZN High Court. And the KZN High Court, the judge president at the time, was hearing the case, and he found nothing wrong with the legislation. So they took the case to the Constitutional Court. And at the Constitutional Court, they said, no, the old legislation is unconstitutional, and the reason is going to render us homeless. And we filed papers saying it's not going to render anybody homeless. This is why. Before a person can be moved, there has to be an alternative place. And if you move them, you can't just do it nilly-nilly. It's got to be in terms of pie. When the case went to the Constitutional Court was actually presented with a case where the whole constitutionality of the legislation was challenged. A day or so before the hearing, they then limited the challenge to 5 sections. They said, no, we are satisfied with the other sections, but there's a problem with just 5. We went to the Constitutional Court, and outside the steps of the court, they said, no, we want to effect further amendments. There are only 3 sections that we want to challenge. And they challenged those sections, and we still had an answer to each challenge that they raised. The finding of the Constitutional Court was that Section 16 of that legislation is unconstitutional. And the reason, because it says you can move people without complying with PI. It didn't say that. It said you can move people, but when you do that, do it in terms of PI. So my challenge was, how could you move them, or how could you order that they be moved if it's going to be not in compliance of PI when the legislation explicitly says do it in terms of PI? So I have the article here. That's all that it said. The one judge who dissented was Judge Yakub at the time. And he gave the reasoning the very same way that we've explained to the people. And in effect, I was agreeing with the minority judgment. But I know that maybe the language I used was too robust in the sense that I was seen to be attacking the Constitutional Court. I wasn't.
Yeah, I did read that article some time ago, and it's good that you are appearing here now and that you've explained yourself. Thank you, Chief Justice. Thank you, Mr. Nkosi.
Thank you so much, sir. Prof?
Thank you, CJ. Mr. Nkosi, could you tell us what your judicial philosophy would be?
Judicial philosophy, I always explain it this way, that the judiciary is like oil. The Constitution is like various cogs, and you need to have the oil to make all the cogs to run smoothly against each other in a way that's going to be harmonious in society. So my reasoning in terms of the judicial philosophy is that it should operate in such a way that there is limited conflict in the society in a manner that is going to be just. It differs in the Constitution in the sense that we all have constitutional rights, but in the process of exercising those rights, they may clash, they may conflict, and things may arise. That's where the judiciary must come in and say, okay, this is how the thing must be regulated in a manner that is going to still be in compliance with the Constitution.
Thank you, sir. And your understanding of the rule of law?
The rule of law is that, my understanding is that whatever, the courts do should actually either not clash with the Constitution to start with, so it should be in line with the Constitution, and it should also take into account the rights of individuals in being exercised, and that there's also room for Ubuntu to be brought into it to ensure that the whole thing is completed.
Thank you, sir. Thank you, CJ.
Thank you, Professor. Honorable Maiman.
Thank you, Chief Justice. Good afternoon, Mr. Nkosi.
Afternoon, Commissioner. I'm really looking in the right direction this time.
Great. I see that in your questionnaire training that you provided is mainly centered around the work that you did with SALGA and municipalities. Yeah. And I want to pose a question around the basis upon which a court will set aside a decision of a meeting of council that is not convened in terms of the standing rules of order. What grounds will you set aside such a decision of a council that is not convened in terms of the standing rules of order? Because the municipal council is a creature of statute. The second point, just to elaborate on that, do you think it is correct sometimes for the court to go to the length of setting aside decision of a political party The basis for these two questions is informed by the opposition party in Cape Town and in Kimberley. In Kimberley, the opposition party convened a council meeting that was not, that did not correct and remove the mayor. So what will be the basis for you to reinstate that mayor? In Cape Town, I think one of the commissioners here, Senior Councillor Mpofu, led the matter of Delil. It looks like the party, I mean the body that terminated her membership was not properly constituted. And the attempt by the opposition party to remove the mayor using that termination of membership was set aside by the court. What will be the basis upon which the court will strike those decisions down? Thank you.
Okay, let's start with the rules of
justice.
Yeah, thank you, Commissioner. Let's start with the rules of order. The rules of order, are like the guideline or the constitution of the council, they are saying we're going to be operating and we're going to follow a certain procedure when we operate, and this is our procedure. And if they deviate from that and they do something that's outside of those rules, then any one of them should actually come up and say, we've deviated from what we agreed. And if that is the case, why should it stand if one of them is going to challenge it? The problem is that as the court, you won't read in the paper that they did this and then do it meremoto on your own. But if one of them stands up to say, it did not happen the way that we said it should, because the reason why you have rules of order is because you need to regulate the process in a way that's going to be acceptable to everyone. So if it's challenged on review by any one of them, it will be set aside on that basis. I'm not sure if I answered that one correctly. Okay, the second one, not even in councils, if you have a quorum, in any constitution that our quorum is this, and you hold a meeting, you find that you don't have a quorum, why are you going ahead to hold that meeting? Or why are you going ahead and making decisions? Because that means the number of bodies who are wanted to make that decision are not there. So if you make that decision, the decision is going to be invalid. But there too, I can't read in the newspapers, the court, and say they did this, so I'm going to set it aside. One of them should challenge it on review to say, this is how it happened, and I want to set it aside. So the court can come to the assistance.
Thank you, Mr. Ngosi. Thank you, Chief Justice.
Thank you, Honorable Muimang. You are excused, Mr. Ngosi.
Thank you very much, Chief Justice. Thanks, Commissioners.
Thank you, sir. Good afternoon, Advocate Sibia.
Good afternoon, Chief Justice.
Are you well, ma'am?
Yes, Chief
Or
Justice.
are you a little bit nervous?
I'm very nervous, Chief Justice, but
Okay.
I'll be okay.
All right. No. Let's take it easy then. I noticed that one of the roles you have played was to approach the state attorney and remind them of their responsibility to brief the juniors who are not getting briefed. How successful were you in that regard? Very briefly.
This was a few years ago, Chief Justice, and I was relatively successful. But the state attorney's office have a funny habit of if you raise a complaint, they use you as the person to address the problem. So, for example, in this case, they immediately gave me a junior who would be a devil, what we call a devil. So when someone is briefed with you in the brief and you both share the same fees. So that's what they did. But I was successful in the way that that meant they could, with that person, they could then never have the excuse that they don't know that person. But I also mentioned a whole lot of other people, and they did get briefs, Chief Justice.
And how successful were you in getting them to pay those who had done the work but were not being paid?
Chief Justice, that is a struggle that we are still dealing with. Soon after there's a complaint, there will be payments, but a few months after the complaint, then the problem will arise again. Even our bar council this year is still involved in that and trying to resolve that. Fee payments by the state attorney are still a huge problem.
I learned that you would pay the juniors who had not been paid yet from your own pocket so that they could survive while they were waiting for fees. For how many years did you keep that practice going?
No, it wasn't for years, Chief Justice, as and when it was needed. So it wasn't something that I did with a view to anything other than as and when someone had that problem and I came to know of it, I addressed it.
Is it fair to assume that that's an indication that, speaking for yourself, the practice was doing very well?
Chief Justice, my practice was going well in terms of the briefs that I was getting briefs. I was also suffering from the same problem of not getting paid on time by the state attorney, but it wasn't so much about the fact that my practice was going well as it was to do with the fact that I was doing better than they were doing. So I could do that. It didn't mean that I had extra and therefore I just had the extra to give to everyone that needed. It impacted me as well, but I understood that they also needed the assistance.
I've also learned from your questionnaire that you've been involved in the empowerment and transformation programs. Are you still involved, or is it something of the past?
Chief Justice, I don't think we can ever say that transformation projects are a thing of the past. So my involvement in different initiatives is not by being a member. It's a lifestyle, if I can put it that way, where we keep trying to assist in transformation. For example, my biggest issue with transformation, or my biggest contribution, what I consider my biggest contribution when it comes to transformation, is with every day. When I get up every day and when I get whatever brief or whatever I am performing, whatever function I'm performing, whatever brief I'm executing, whether I'm acting as a judge, whatever I'm doing, is to do my best, because there's a narrative that Black counsel, Black females are not competent. So each day and with each brief, with each instruction, I do my best, and I trust that with the good work that I do, I'm slowly but surely changing the narrative, and that would change the story that Black women are incompetent, or whatever excuse is used when we are not briefed.
I often get my computation wrong when I don't use my fingers. But is it fair to say that you were an attorney for about 9 years before you became an advocate?
Chief Justice, I was admitted as an attorney, but I worked at the Road Accident Fund for 9 years. However, when I applied there, it was a requirement that you must be an admitted attorney in order to be appointed for the work, and I was practicing law.
And for how many years have you been an advocate?
This is my 13th year.
For how many weeks or months, whichever one you prefer, have you acted as a judge?
I have acted as a judge for 3.5 months in total.
Yes. I can see you are comfortable now. I'm going to have the JP put questions to you, but before that, colleagues, may I have the names of those who have questions for that? Okay.
Makwanisha.
Matolo Dlepu.
Matonsela. Lamola.
Bono.
Lamola.
Schlemmer.
Tepe.
Honorable JP.
Thank you, Chief Justice. Just shortly, your acting stints were both in Durban and in Pietermaritzburg.
Yes,
And
JP.
one of those stints, I think, I wasn't the senior judge over there, but from all accounts, you did well wherever you were. And from your side, how do you feel you did while you were acting?
JP, I feel that I did well because firstly, when you are acting as an acting judge and you come from the bar, and there is the issue of briefing patterns, and what that means, the skewed briefing patterns mean that there is a certain amount of work, that type of work that you are never actually exposed to in your career. So you get to deal with concepts that you last heard in university and things like that. Considering that we have those obstacles, I felt that I did well because it became normal to sleep for 4 hours and prepare and make sure that by the time I go to court, I know everything there is to know about each matter that I'm going to be dealing with. And also from the response that I received from those that appeared before me, I felt that I did okay. I also got similar feedback from the judges that were with me at the time.
Yes. I don't recall you having had any difficulties with any particular matters, but are there any that you felt were particularly difficult for you to deal with?
by the time I dealt with them, JP, with all the preparation that had gone into it, I felt that I was prepared.
You've got no outstanding judgments, as far as I know.
No, JP.
And what was your usual turnaround time for getting a judgment out?
Well, it differs. From the first time that I acted, that period, I took a longer time to deliver the judgments, so that for that period, there was a judgment that I handed down on the last day of the 3-month period. But otherwise, everything else was earlier than that. And as I have acted more, I have been giving out judgments as and when. The last time I acted this year, JP, when I finished the acting, I did not have any outstanding judgments.
And I think you one of the few acting judges that it was your second stint that had a judgment go up to the Constitutional Court. Is that correct?
In my first
Your first stint?
Yes.
They took you up to the Constitutional Court.
Yes, although the Constitutional Court was not very kind to me, but yes.
But other than that, you managed quite well.
Yes, JP.
Yes. Thank you, Chief Justice.
Thank you, Judge President. Honorable MEC.
Thank you so much, Chief Justice, and good afternoon, Advocate Spear.
Good afternoon.
On the issues of empowerment initiatives that you have participated on, which ones can you say were successful?
Well, it is actually a dual empowerment initiative, where I believe I empowered and was also empowered. I don't think it appears in my application, but for example, when we were advocates and we were starting out, one of the leading senior counsels was retiring from practice, and I was approached by another Black female who was senior to me to take over that section that he had been occupying, and for us to form a group of advocates. And she and I, and in fact there were two ladies, one was junior to me and one was senior to me, and we started this group, which has in the end produced, that lady subsequently became senior counsel, and she has acted, I have acted, she assisted me when I was preparing to act, and we also had another acting judge. But my biggest success story in terms of empowerment is in relation to another junior lady that who started practice, and when she started, I allowed her to share my chambers, and for a year, for that first year, and also that helped her with how to run practice. And I am proud to say that she's still in practice and doing very well. She's a Black female. And when I started practice at the bar, there were, in terms of African females, there were 6. And because they were leaving, the difficulties with finances and with the work meant that people left because they couldn't sustain their practices. So this lady that I assisted did not have a background where she could call home for assistance. So I believe that what she learned during that period in terms of work ethic, because also she was coming out of university, so she had never been employed, in addition to everything else. I believe that is my biggest contribution.
Insofar as transformation,
yes.
What areas do you think demands more attention in order to complete the project of transformation in the judiciary system?
In the judiciary?
Yes.
Okay. I believe that to complete the transformation of the judiciary, unfortunately, in my division, the division that I'm applying to, I'm not aware of training programs for aspirant judges and women and any such thing. And before I acted, I had never received any training that is geared towards someone becoming a judge. And in fact, we received training this year of the SAGEL aspirant judges course. That's when we received it. It was this year for the first time. So I think the transformation needs can be addressed by offering more training to people that are still not even considering acting yet, but identifying people with an interest, with that desire to serve, and giving them the necessary training so that when it comes to this moment, you have a number of people that can actually be appointed to the bench.
Thank you, Chief Justice.
Thank you, MSc. Honorable Maganisha.
Chief Justice, can I just make a follow-up, then I'll forfeit my slot.
Yes, please go ahead, ma'am.
Good afternoon, Advocate Sibia.
Good afternoon.
I really want to applaud you for taking up the fight for transformation of women. But what I just wanted to find out from you, the fight is still on. It hasn't,
yes.
But what do you think, now that you want to jump ship, what do you think we can do to fast track this fight? Because, it's just taking too long for the powers that be understand that it's a fight.
Yes. I think there needs to be a will, unfortunately. And that will needs to be with the attorneys, the will to transform, unfortunately, because even though I have been fortunate and I have got good briefs in my career, and there's still, the briefs come only from certain firms and the state. And you will find that people will know you are there. They will know you do a good job, but they just won't brief you. Because I don't want to say because I am Black or because I am female, but sometimes you can't help but think that is the reason. So it has to be a change of will. And that's why I was saying that for me, with each day that I perform and that I execute whatever brief I'm given, I'm hoping that that will change how Black women in particular are viewed. And I believe that it needs to be us also as ladies that are championing the fight. So, for example, for us to bring in other females into our matters, so that we expose them to the work and expose them to the people that will potentially brief them.
Thank you, CJ. Thank you.
Thank you so much. Honorable Maganisha.
Thank you very much, CJ. Good afternoon, Advocate Sibia.
Good afternoon.
Thank you for the good work. But my question is, when you help these pupils and recently qualified advocates, do you take them through the same value systems you have? Or you just assist them, hoping that they will, that value system will be assimilated? Do you take them through?
I believe that by the best way to lead is by example. So I don't necessarily say, don't forget others, make sure you teach others. I don't do that, but I believe that the best way is to be a good example.
Maybe a combination of both.
Yes, yes. When you have a pupil, like at the moment, I have a pupil and it's a black lady. The pupil gets the benefit, the full benefit, because I am a mother and I like telling people what to do and why. So as a result, if you are a pupil with me or a pupil in my group, you get the benefit of both.
No, thank you very much. I'll just would like to ask you two or three questions on the same issue. As the Bar Association of KwaZulu-Natal, or as a group, have you done any form of survey of the impact of late payments of advocates, especially your junior advocates by the state in particular? Because at face value, you would conclude that if you are paid late, you are more likely to take loans, and loans attract interest. But have you been able to do any kind of a study to say how many of them have left because of late payment, and how many have left the profession because they're not getting briefs?
I don't believe that there's ever been a formal study of that nature. Every year that is undertaken, a study to find out how people are doing in terms of payment, especially late payments, are conducted. I was not part of the Bar Council last year. One of your commissioners was the chairman at the time, and they introduced a system in terms of which they allowed the sharing of chambers, which is something that is not normally allowed, in order to assist other people. And that was mainly because of COVID, and there were various other measures that were put in place because of COVID. But each year, for the past, I don't remember how many number of years, but at the time, Advocate Ngalwana was the chairperson of the GCB. From that period until now, the Bar Council actively seeks to ensure the payment of juniors, especially by the state, is timeless. So every now and again, in fact, last week or the beginning of this week, there was another circular for people to inform the Bar Council if they are having difficulties with payments of their fees by the state.
Last question, CJ. Do you think this late payment, is it because of capacity problems or is it malicious?
I'll go with option C. I wouldn't want to think it's malicious. I think it is mostly a lack of empathy, that when they don't realize the actual crippling impact it has on people when you pay them late for work that they have done. So I don't think it's malicious, but I think there's just that, because they get paid monthly whether they work or not, so they can't empathize.
Thank you very much, Advocate Sibuya, and thank you very much, CJ.
Thank you, Honorable Magwanisha. Commissioner Lepu.
Thank you, CJ. I forfeited my slot because I did a follow-up of what I wanted to ask.
Thank you so much, ma'am. Advocate Madonsela C.
Thank you, Chief Justice. Good afternoon, Advocate Sibuya.
Good afternoon.
Unfortunately, contrary to your request that I should not say anything and ask you any questions today, I have to do it in the exercise of my duties. Firstly, a disclaimer, you are my colleague and friend, and we are in the same group. That's why you made the request. But lest there be any doubt, amongst the commissioner's mind. You delivered a judgment which the JP asked you about in the Varsity College matter, which went all the way to the Constitutional Court. In that case, you found, did you not, that the approach of the Law Society and in refusing to recognize the LLB from Varsity College was wrong and unconstitutional. You ultimately declared that statute unconstitutional, and it went to the Constitutional Court for confirmation. And you say today that the Constitutional Court was not kind to you, but it's not so much that the Constitutional Court differed with you on the result. It just did not agree with you with the approach. It rather approached the matter from a interpretational aspect rather than confirmation of declaration of invalidity. Is that not correct?
It's such a difficult question to answer right now because the Chief Justice penned the judgment that I'm complaining about. So we have that difficulty. But in effect, what the Constitutional Court differed with me on, and this is the Chief Justice's main judgment, was my approach in the interpretation, in that he felt that I had interpreted the Higher Education Act, which was not challenged, and that I should not even have gone there. I am happy to say that there was a second judgment which said that my approach was actually not wrong and had been followed previously by the Constitutional Court. Although at the end, she also agreed that I did not have to strike down the legislation. So I appreciated that. The reason that I say they were harsh is because I felt that the judgment could have been written the way it was written in the second judgment. So.
Thank you.
For what it is worth, Advocate Sibia, the Honorable Minister is here. He has practiced as an attorney and is a double master's holder. He thought your judgment was so right that he immediately undertook to cause the necessary legislative amendments to be made. The Law Society, the Legal Practice Council agreed with you. Their advocate agreed with you. You went out of your way to make sure that justice was done as you saw it. I don't think you should be as harsh on yourself as you are now being. You actually did well. You grappled with the issues from a constitutional perspective. That's why you found that the section was unconstitutional. I think you are being unduly hard on yourself. Anyway, Honorable Partner.
Chief Justice, on that aspect,
yes, sir.
On that aspect, I wanted to address it the way you did, that she's too harsh on herself because she did very well on that judgment. But then I wanted just to correct, it is not Varsity College, but it is the Independent Institute of Education. Thank you.
That is Varsity College.
It is Varsity College. It's used interchangeably.
Okay, if that is the issue, because I thought a Varsity College affiliate to this body as one of the education institution. If that is the issue, then I got it wrong, but I thought that is how it is. Thank you, CJ.
Thank you, sir. Institute of Education Pty Limited, but it's also referred to as Varsity College in the course of a judgment. Commissioner Barnard?
Yes, thank you, Chief Justice. I think they're only the Varsity College, that's why they refer to it like that. Correct. Also on that, if I can maybe comment also, Advocate Sabia, good afternoon. I think what's important is many young students were assisted, or people that had to start out the law practice soon were assisted in that matter. So it gave hope to people, if I can put it that way. If you had to choose, I'd like to ask you, if you had to choose between speed and thoroughness, I'm just trying to test the priority or your approach to judgments. Between speed and thoroughness in your judgments, which one would you opt for and why?
I don't believe that it's one or the other. I believe the work of a judge is, I want to say, 24 hours a day. So there's this nice phrase that we all grew up hearing, which is justice delayed is justice denied. But in order to get to what is justice, you need to be thorough. So to me, it's not one or the other.
Thank you very much. Thank you, Chief Justice.
Thank you very much, sir. Honorable Minister.
Yeah, thank you, CJ, and good afternoon, Advocate.
Good afternoon, Minister.
I'm a bit curious here. I see that you also chaired, you also were chairperson of an internal appeal of a disciplinary inquiry for KZN All Boys Private School. How did that work?
It's an internal inquiry, but they choose an external chairperson. So that's how it works. Not that it becomes an external inquiry.
Oh, okay.
Yes.
No, that's fine. I was just curious that I see it's an all boys school.
No.
But my question relates to the work you did for the Seriti Commission of Inquiry. I know it might dampen your spirit, but given the prevailing currently Commission of Inquiry into state capture, what lessons do you think you learned there which could be helpful for the current Commission of Inquiry that is sitting on state capture?
Minister, that's a difficult one to answer simply because I was part of the arms deal inquiry and I am part of the state capture Commission of Inquiry. But the lessons that we learned, that I felt are applicable and are in fact not being repeated in the current Commission of Inquiry is that the chairperson's role versus the independence of the council that are employed to lead the evidence. In the previous one, I felt that was blurred. In the current one, despite what appears in the media, I am not finding it there. I'm not finding that the lines are blurred. There is independence that is given to council.
Okay, no, that's fine. Maybe as a bit of a follow-up for us, as we look at the commission and we support its work, we are just worried about the overriding cost that we are dealing with as a department. You might be aware now that we're dealing with issues of extending the budgets and so forth. What could you advise the Department of Justice in future as we formulate commissions of inquiries in terms of reference so that we don't have them going on, and also the costs are still within manageable limits?
My personal view would be that it would be better if the fees, because I believe that the issue, the highest cost would be the fees of counsel, and I am not going to be popular for what I'm about to say, but I believe that just as serving on the bench, a commission of inquiry is a service to the country. So I don't believe that people should not be allowed to make a living, but for those that know, or rather for the benefit of those that don't know, advocates charge per hour and per day for the work that they do on an ordinary brief, on whatever brief they have. But the benefit of a commission of inquiry is that you get to charge for every hour that you work, which you actually can't do in practice because the fees would be astronomical. So in a commission of inquiry, what we were able to do was charge for all the hours that we work. Now, I'm not saying that that is a bad thing, but it does amount to a nice sum at the end of the month than if you were in practice. So my recommendation would be that a discussion is had with the people prior to appointing them to a commission of inquiry, and to get a similar understanding that this is actually a service to the country and that there will be some extra benefit as opposed to what you would be getting in practice, so that a fee arrangement that would limit in certain respects the costs, I would recommend something like that.
We are going to use this recording for the negotiations.
Can I have a follow-up, CJ?
CJ, thank you. That was my other question would have been about the varsity college, but I think it has been traversed enough. Thank you.
Thank you, Minister.
Can I have a follow-up?
Thank you, Minister. Yes, Advocate Mpofu, I haven't heard you throughout the day. I thought you were not here.
No, I'm contemplating, CJ. I'm here. Chief Justice, I'm sorry, good evening, afternoon.
Good afternoon.
Thanks. Yeah, well, since you already, it looks like you are prepared to be unpopular, I have to ask you a question which I didn't want to ask you because I thought you are scared of being unpopular. What do you think of the, and I take your point about commissions and limiting the fees in particular, but what do you think about, since you are a champion of briefing patterns, what do you think about the briefing patterns in the commission that you are in now? Where there are 7 white male senior counsel?
I do not know the reasons why there are 7 white male senior counsel as opposed to other people. By the time that I joined, a number of the senior black counsel that had been there had left by that time.
Oh, I see. You haven't been there since the beginning.
No. I only joined December 2019. Okay. Yes.
Okay. Well, irrespective of that, what do you think of like a situation you found there?
It is discouraging.
Thank you. Thank you, Chief Justice.
Thank you so much, Sok. Prof.
Thank you, CJ. Good afternoon, ma'am.
Good afternoon,
Will
Prof.
you share your judicial philosophy with us?
When you ask a question like that, I feel like you expect a very sophisticated answer.
Doesn't have to be.
But basically, I believe there's wrong and there's right. And I believe that it is the job of the judge to correct the wrongs and make them right. And I believe that in undertaking that process, one must have regard to the Constitution and the laws. So those determine what is right and what is wrong and how the wrong must be corrected. So I believe in justice.
Thanks very much. Thank you, CJ.
Thank you, Prof. Commissioner Tsepa.
Thank you, CJ. Good afternoon, Advocate Sibia.
Good afternoon.
I just want to commend you on the work you have been doing, and mentoring younger women who are coming into the bar. It's a very good work, and hope you continue to do it, even if you are appointed onto the bench.
Thank you.
My question was, what do you think could be done to assist newly appointed judges to settle into their new roles, in terms of running courts and writing judgments once they are appointed?
Thank you. I already indicated that I'm not aware of a program in KwaZulu-Natal for those that are going to act. So there might be a program for those that have just been appointed. But I believe that what should happen is something that I heard when I was every now and again listening to the interviews during the week, where I heard in one division they have a standing Friday training session. So things like that I thought make a lot of sense. But I actually believe that the greatest assistance that you can give is to expose the judges to the difficult cases and offer to assist them where they find difficulty, because I don't believe that we should approach newly appointed judges as judges that don't know the work. I believe that we should approach them as people that are competent and capable. And I don't believe anything trumps experience.
Thank you, CJ. Thank you, Advocate Sibia.
Thank you.
Thank you very much. You are excused, Advocate.
Thank you, CJ, and thank you, commissioners.
Thank you.
Is it okay? Okay. Do you want me to just come a little bit further forward? Thank you. Thank you very much.
Greetings, Advocate Topping SC.
Greetings, CJ.
How are you, sir?
As usual, a little bit nervous, but I'm fine, CJ. Thank you very much for asking.
Okay, yeah. Okay, let's have a slow start so that you can get into it.
Yes.
You practiced as an attorney for about 3 years after admission, am I right?
Yes, I did 2 years articles, and I think it was 3 years as an attorney, and then I was 2.5 to 3 years as a prosecutor before joining the bar.
Yes. Why did you leave the attorney's profession for for the prosecution?
I wanted to come to the bar, and in those days only advocates appeared in the High Court, and most of my practice as an attorney was in maritime law, where it was all in the High Court. So although I had experience as an attorney, I had no experience as it were on my feet in court, and I wanted to make sure I could do that. And I also had no criminal experience, and that's why I went to the prosecuting authorities and went there for 3 years to get court experience and get some confidence on my feet, as it were, to come to court.
Yes. And you've been an advocate in the private in private practice for about 28 years, am I right?
Yes, 1992. That's 28, 29 years.
Yes. And of those 28 years, you spent just over 6 as silk.
Yes, I took silk in 2014. I think you said on the previous occasion, I applied in 2012, and then there was a hold up of the applications because there was a challenge to the state president being able to bestow honors. So that was delayed for 2 years.
Yes. And have you been doing well in practice?
I hope so.
Notwithstanding the COVID challenges?
Well, can I say I'm comfortable? The COVID challenges very much. This last year, obviously, it's restricted a lot of appearances in court. But yes, thank you. My practice is fine.
Well, are you comfortable or very comfortable? You really don't have to be too humble.
Sorry, I couldn't hear that last bit.
I was saying, are you comfortable or very comfortable? You don't have to be too humble.
I don't think I can say very comfortable, but I'm comfortable. I'm comfortable enough. I live a simple life.
Oh, okay. And you've acted several times as a judge of the High Court, am I right?
Yes, I have. Just as far as my acting is concerned, on the last occasion, there were some comments that maybe I hadn't acted long enough. So this year, with the constraints of COVID and obviously taking account of my practice as well, I've tried to act as much as I can this last year. I don't know if you want to know about my acting and what I've done and what I haven't done. I think it is relevant for the Commission to hear what I've done. I've now got some 11 months of experience as an acting judge. I thought that would be a little bit meaningless if you didn't know what I'd done during that time. So I went through my bench books and saw what type of work I've done. I've done over 50 opposed motions. I've done 13 trials, of which one is still a part heard. I've sat on 25 separate appeal benches. I've presided over motion court on 27 occasions, and I've scribed 37 written judgments, of which 2 are reported. And that's what I've done during my acting career.
Thank you. Colleagues, may I have the names of those who have questions for the advocate?
Sigogo.
Nyambi.
Schlemmer.
Prof first and both.
And Dodovu.
Tsepe.
JP?
Thank you, Chief Justice. Advocate Topping, as you say, you have vast experience both as a practitioner and on the bench. You've acted, as you say, for 11 months.
Yes.
Yes. And my recollection is that it's both in the criminal and the civil courts.
Criminal appeals.
Yes.
I was due to do a criminal session before
COVID.
Christmas, but with COVID, then the criminal side, I reverted to a civil session.
And you say you prosecuted for a while.
Yes, well, for 2.5 to 3 years.
Yes.
That was after I was an attorney, and during the last, should I say, 18 months to 2 years of that prosecuting, I was what was styled as the specialist prosecutor.
doing mainly commercial crimes and unpleasant crimes, should I say.
Now, with all your experience in the legal field, what do you say you could bring to the KwaZulu-Natal bench?
I've always, on my first interview and now, I've always been of the view, and I still remain of the view, that I can make a positive contribution to it. My mannerisms and my nature, I'm always prepared to hear two sides of the story. In practice, it's served me well because I'm able to debate and settle matters and civil matters and so forth. I've also tried during my acting time to allow counsel, especially junior counsel, to develop arguments. I've never tried to cut them short. I've tried to encourage junior advocates to be a little bit more relaxed in front of me. I've also tried to relax lay litigants and lay witnesses so they can tell their full story. I've had some positive feedback from that and from my colleagues. I've had no criticism in the manner in which I've conducted myself in court. That I think is a positive contribution. And also, as I just said to the Chief Justice, I've got a very high work ethic. And that will continue throughout. I don't leave things be. I finish them. If I have to work in the evenings, work over weekends, I get things done and I don't let things lie around. At that level, I think I can make a very positive contribution to the bench.
Other than the one part heard that I know of and you mentioned.
Yes.
There's no outstanding judgments.
No, there's two from the last session. I've got two reserves, which I'm scribing at the moment. I should have them finished in a couple of weeks.
How long have they been reserved?
From this last session, so it was from February.
I see. Since February?
Yes, February, March session. So they're not outstanding for too long. Everything else has been handed down. Well, when I say handed down, they're now published via email. But everything else has been finalized. I've got nothing outstanding except those two.
As far as the work in the High Court is concerned, what challenges, if any, did you experience?
Comparing with practice, the challenges are kind of the same. To get through the work, to hear cases, to hear them efficiently, to hear them expeditiously. I think that is the challenge, is to try and get the workload out, because as far as I'm concerned, the most important person in the courtroom is the litigant. And they need to know that they've had a fair trial at the end of the day. And that's always a challenge, to get through the work in time. Just at that level, I don't know, again, if it's relevant, written works I do myself. I don't rely on secretarial services to type and so forth. And that's why I can get through a workload quite high, because I can work in the evenings, work over weekends if needs be.
Yes. Thank you, Chief Justice.
Thank you.
Thank you, Judge President. Honorable MEC.
Thanks, Chair. Just one question, the advocate, and good afternoon.
Good afternoon.
I'm this side.
So I'm backing to see.
This side.
Oh, sorry, I do apologize. Okay, thank you.
No, just one question. What offerings do you have insofar as transformation is concerned?
What have I done for transformation?
Should you also be given a chance, or should you be appointed?
Yes.
What novel things would you bring about to advance transformation?
Yes. What I have done in the past, and I think it's in the reports and so forth, I've been very involved in pupil training throughout my career. I've tried to impart whatever knowledge and experience I've ever had to the junior members of the bar. Right up to this last session, I actually, myself and acting judge, sat on the bench on what they call mock trials, to try and, whether the pupils came and appeared before you, and to take that through. I've been, or I'm on the Bar Council now as the senior silk, but prior to that, I was the pupil convener. When I first started, that was either 5 or 6 years ago. Myself, and I must say with a large measure of input from Commissioner Madonsela and erstwhile Commissioner Thandi Norman, we implemented a point system to, if anything, bring in
the ills of the past and get the demographics right for the intake of pupils at the Durban bar. Points were allocated on gender, on race, on experience, on qualifications, and that I think, and I would like, because it's still in place now, has transformed to an extent the intake of the juniors at the Durban bar and transformed the junior demographics at the bar, and that over time will filter through the bar as those juniors get more and more experienced and more junior members join. As far as transforming on the bench is concerned, as I've said, my nature itself is to try. When I first was a junior advocate, a courtroom was a very hostile on sometimes occasions and always a very tense and unpleasant experience with some judges. I've tried to move away from that and make it, although always an air of decorum and control, but to make it more relaxed and let people tell their story, because that's the important bit, is that the litigant must feel that he had a fair, or she had a fair trial when they walk out of court. And at that level, and I hope I've transformed the ethos in the hearings that I've had. And also, if I am appointed, I would like to continue my association with training of junior practitioners. There, a lot of input, whatever experience I have got and whatever knowledge I have got, I'm very willing to try and impart to junior members. So at that level, I hope I can assist and move forward the court in Durban, or Pietermaritzburg.
Do you believe that we still have attitudinal problems in the system that probably may hamper transformation?
You say attitude problems?
Racial attitudinal problems.
I haven't come across. One hears stories of unpleasant stories, which I certainly do not support in any way whatsoever. But I think that the bench and the bar and all the professions are being transformed, but it's a process. The past was there for a very long time, and we need to work through that. But I've never come across, I get on very well with all my colleagues, all the members of the bench, no matter what race or gender or beliefs. I just make sure that I deal with everybody and I accept everybody for who they are and what they are. It's the way I conduct my life. So maybe that's why I don't get, or I haven't come across any problems at all.
Okay, thanks, CJ. Thank you so much.
Thank you very much.
Thank you, MEC. Commissioner Sigogo.
Thank you, CJ. Good afternoon.
Good afternoon. Good afternoon.
You left the sidebar.
Yes.
To join the bar because your line of work was on maritime law, which is high court work.
Yes.
When you were still an attorney, did you brief black advocates to do maritime law?
At that stage, I don't think there were unfortunately, any black advocates that were skilled in maritime. It was a very closed shop, if I might say so. And I'm talking back now to the 80s, the early 80s. That's when I was there. And also, when I say I was an attorney, I was an associate. So in other words, I wasn't running my own firm, and one does what one is told to do. But at that level, I'm just trying to think.
I think Judge Square was there as an advocate during that time.
Trying to remember, I think he might have, in matters I was involved in, but again, it wasn't me, it was obviously my principal were briefing and I would be involved in the cases.
Let's come to the present.
Yes.
You indicated that there are some initiatives that you engaged with Advocate Madonsela SC,
yes,
as well as Tandinomen SC.
Yes.
In those initiatives, do you include transference of skill in as far as maritime law is concerned to black practitioners?
That was what we initiated, was purely a criteria for the intake. In other words, who should be accepted as a pupil member of the society. I must say, my maritime experience as an advocate is quite limited at the level. I haven't got a maritime practice, as it were. So at that level, but at the level of training pupils, I don't think there is any training as far as maritime law is concerned specifically. That kind of comes afterwards when one molds one's practice towards it.
One last question, CJ. Understanding that your maritime practice was not as active now as a counsel, but there, when you got 1 or 2 briefs, did you take along black female advocates with you in order to transfer skills to them in terms of maritime law?
Okay, as far as maritime law, no, because I've never done big maritime cases as a silk. But as far as my silk's practice is concerned and the general litigation that I do, very much so. I've always, whenever I can do, because one can't just demand a junior, try and encourage attorneys to brief me with a junior. And on most occasions, I can only think of 1 or 2 where it hasn't been, where it's been a white junior. I've tried to encourage, and a number of members of the juniors of the bar have been my juniors throughout.
Thank you, sir. Thank you, CJ.
Thank you very much.
CJ, may I be allowed a quick follow-up on Mr. Skogo's question on maritime law?
Please go ahead, President.
Thank you, CJ. Good afternoon, Mr. Topping.
So I can't pick up. Oh, sorry, I'm looking around the room. I apologize.
Look at the screen.
No,
Not in the room.
I do apologize.
Just one quick issue.
Yes.
If the appearances at the SCA in maritime law cases are anything to go by, then I just want to put to you that the area of maritime law remains very much a closed shop, because I've yet to see we hardly see black counsel in any case. Yes. But certainly in my 17 years there, I've yet to see a junior or even a pupil
coming through
accompanying a counsel who've come to argue maritime law cases.
Well, that with respect needs to be addressed, because I'm going back to the 80s when my involvement was, and I don't like using the term closed shop, but I think that maybe it proceeded through, and I agree with you, it ought to change. But
I'm sorry that it.
Sorry, I must also emphasize, at the level of the 80s when the Act first came out, there was a lot of maritime litigation here, especially in Durban court. That has waned quite so significantly because all people are now arbitrating in London and so forth. That volume of litigation in Durban especially has died down a lot, that I am aware of.
That is true. No, thank you very much, Mr. Topping. Thank you, CJ.
Thank you, and I apologize for not finding you initially.
Honorable Nyambi.
Thank you, CJ. Evening, Advocate Topping.
Good evening.
The last time you were here was in April 2018 for the same position.
Yes, it was. Yes.
You might be aware that you are competing with other 7 for the 3 positions available.
Yes.
So from 2018 April to date, anything that you think is very significant that we have to consider today that you have done?
Just at the level I've done much more acting. I've actually gone out of my way to try and take heed of those criticisms initially that maybe my experience on the bench was a bit limited. And especially this year, I've dedicated as much time as I can to acting and getting more experience on the bench.
Do you think now we are more ready than we were in 2018?
I'm more confident in myself and more confident that I can fulfill the functions, because with experience comes confidence. So at that level, yes, very much so. And especially this year, because I've had long stints where you kind of get into the swing of things, as it were. So yes, very much so. And I still feel I can make a very positive contribution if elevated.
I commend you for not giving up.
Pardon?
I commend you for not giving up.
Well,
Thank you.
It's always been a goal of mine. When I joined the bar, I wanted to finish my career on the bench, and I'm trying to achieve that goal.
Thank you, Advocate Toppings.
Thank you very much.
Thank you, CJ.
Thank you, Honorable Nyambi. Prof?
Good afternoon, sir. Thank
Good
you, CJ.
afternoon.
I've asked all the other almost all the other candidates their judicial philosophy. Would you mind sharing that with us, please?
So could you just elaborate?
Judicial philosophy.
Philosophy, so I don't really understand the question.
Well, what do you consider when you sit on the bench before you come to a final conclusion? What filters through your head? What is your judicial philosophy?
Well, hopefully coming to the right decision eventually by applying the law. As I've said, my philosophy and as far as practical is concerned is that the most important person is the litigant. But coming to the right decision based on the law and the facts. I've always tried to achieve that. And I think one of the comments was from one of the reports I received dealing with the written judgments that I've done. The comment was that they are well-reasoned and thorough. And that's what I've always tried to do, to make it, if one reads what I've produced, to place you as close as you can to what transpired in court, what the law is, and that's why I've come to that decision. So if anything, thoroughness, I think, and coming to the right decision is very important to me.
Thank you. And the rule of law, what is your understanding of the rule of law?
Rule of law, well, we all before the law, we all before the Constitution. But it goes further than that. There's no one above the law, but it goes to also laws need to be certain, they can't be retrospective, and there has to be rationality and so forth. But much more that I think important is that everybody is subject to the law, no matter what you are or who you are.
Thank you, sir. Thank you, CJ.
Thank you very much.
Thank you, Professor. Advocate Mbofu, SC.
Thank you. Good evening.
Good evening.
SC. Yes, I just would like to ask you one question. It relates to some of the issues that have been raised about what you call the cartels and all that in terms of the briefing patterns.
So I'm battling to hear you, sorry.
Sorry. Okay, let me bring it closer. I was saying I'm going to ask you one question which relates mostly to what you've been questioned about regarding briefing patterns.
Yes.
Which you've correctly pointed out have been skewed since the 80s until now. I wanted to test an idea, seeing that you're senior counsel. It is my view that senior counsel in particular have a considerable amount of weight on attorneys. In other words, if you insist, like I do, that I'm always going to have a black woman as a junior in a matter, I'm sure one or two might say no, but by and large, people will go with what you are saying as the leader. So how can we harness that power to ensure that there's a real change? And I'll give you an example, if you excuse me, CJ. In Johannesburg, when I was the chair of the Bar Council, together with a few other people, we sponsored a rule that said, you may not have a team of 3 counsel, which are all white. So every third person must be a black male or female, okay? As you can understand, when it came, there were all sorts of grumblings. But now it's practiced as second nature. People don't even think twice. It's, like the smoking laws. When it comes, people complain. But if you don't actually legislate, and my view is that maybe the time has come now for change that 3 counsel rule to a 2 counsel rule, to say you must, in every team of 2, there must always be black or female counsel. And of course, I'm sure there'll be a whole lot of noise again, but it will go a long way into empowering hundreds and hundreds of people. Would you agree with that kind of approach? Obviously, there has to be consultation and all that, but that there should be, we can't just leave it to chance and the good hearts of people.
No, very much I would support that there has to be a transformation and skills transfer. in the old days, I don't know if I'm using the right term, but always you never briefed a silk without a junior. Those rules have kind of gone. There's economic pressures as to what the case is worth.
Yeah.
But very much so, it should be encouraged. Yes, a transformation and skills sharing throughout, and very much so the junior bar, because they filter up, become seniors, and then that philosophy then follows all the way through. Yes, I'd very much support that.
Yeah, because we do agree that if there was a rule like that, then what President Maya is talking about would not happen.
Yes.
Because it would be in all those maritime cases.
Yes.
There would then be at least skills transfer almost automatically.
Yes, it would happen automatically. Yes, and I agree with you, and I'd support it.
Thank you.
Thank you very much.
Honorable Dodovu.
Sorry, thanks, CJ.
Thank you very much, CJ. I'm covered. I'm happy. Thanks.
Thank you.
Thank you, sir. Commissioner Tsepe.
Chief Justice, thank you. Good evening,
Good evening.
Advocate. I'm generally covered. The one thing I wanted to ask you as a follow-up on training, particularly of pupillage in a bar like Durban, you said that you do not cover maritime law. Why is that?
I honestly don't know. I'm no longer the pupil convener, so I'm out of that. And I'm talking off the top of my head. I'm not sure if it is covered or not. I think it's more, as far as the pupil training is concerned, it's more the basics of how to appear and the rules of court, those basics. And then Maritime comes afterwards. But I don't think there's specifically, I really don't know.
Thank you. Thank you, CJ.
Thank you.
Thank you so much, Commissioner Tsepe. Advocate Topiasi, you are excused, sir.
Thank you very much, Jose. Thank you, everybody.
Thank you.
Thank you.